Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, but we'll only hear 3 of them in this courtroom. We will hear those 3 cases in the order in which they appear. Each side has 15 minutes to present your argument. The appellant may reserve up to 5 of those minutes. So when the appellant comes to the podium, please introduce yourself and then tell us how many minutes you want to reserve, and we'll program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Annie J. Jones, buying through her conservatorship, Joyce Sons, aka Calissa Joyce Sons, versus Life Care Centers of America, doing business as Life Care Center of Tullahoma.
Good morning.
Good morning. May it please the court. Good morning, Your Honors. My name is Sarah Martin, and I represent the plaintiff on behalf of her mother, Annie Jones, who is now deceased. I would like to reserve 3 minutes for rebuttal.
3 minutes. Okay, thank you.
Your Honors, this case involves a nursing home employee video chatting with her incarcerated boyfriend while bathing Annie Jones, a vulnerable nursing home resident with severely impaired cognition, exposing her nude body on camera to not just the inmate, but the persons reviewing that video, including people at the nursing home and also the person at the jail observing all of the calls that came in and out. This violated Ms. Jones' privacy and dignity, and it's undisputed that it constituted abuse in this case. This case was dismissed because the trial court determined that Ms. Jones was unable to appreciate that abuse occurred and thus could not have suffered a compensable injury. This court should reverse the trial court's dismissal for 2 reasons. First, because the Healthcare Liability Act is broad enough to include the invasion of Ms. Jones' legally protected interests and privacy and dignity as a cognizable injury, considering that the HCLA contemplates literally any theory of liability. And second, because we are a civilized society and we should value the deterrence of abuse and neglect of those most vulnerable people who cannot protect themselves. Stated another way, Your Honors, the primary question this court has to answer is this. Is abuse that causes a loss of the right to privacy and dignity a compensable injury under the Healthcare Liability Act? If the answer is yes, but only if the victim is lucid enough to know what is going on, there is no incentive for nursing homes to provide good care to the most vulnerable residents that may not understand what's happening to them.
Ms. Martin, that's certainly an important point of life and responsibility, but it doesn't this case hinge upon the fact that no one told Ms. Jones that this happened, and thus she was never aware of it?
Yes, Your Honor, but it's important to note that, first of all, it shouldn't be a matter of we have to tell and re-traumatize this person who might not even understand or might then immediately forget what was told to her. This case shouldn't hinge on that.
Yeah, and I agree. I'm struggling with that concept myself. It troubles me that this lady was exposed wrongfully. But I respectfully believe it's not a question, the issue doesn't hinge upon her mental incapacity, but it hinges upon the fact that she didn't know. So my question is, can there be a remedy? And if so, what is the remedy? When a person's body is exposed to others, but they never know about it. What legal principle, what case, what authority can we rely upon? And I say that because I respectfully believe it's not hinging upon her mental incapacity. Respectfully, I say that.
Your Honor, I do respectfully disagree just because I think it's a distinction without a difference. I think if you have a resident who doesn't know and you have a resident who can't know, because of their mental incapacity. I think those are one and the same. But to answer your question, the HCLA in our position is broad. Healthcare liability action is defined as any civil action alleging that a healthcare provider or providers have caused an injury related to the provision of or failure to provide healthcare services to a person, regardless of the theory of liability upon which the action is based. And that's Section 102A of the Healthcare Liability Act. The Supreme Court in Ellithorpe versus Weismark determined that the HCLA establishes a clear legislative intent that all civil actions alleging that a healthcare provider has caused an injury related to the provision of or failure to provide healthcare services be subject to the HCLA, and this is key, regardless of any other claims, causes of action, or theories of liability alleged. And given that broad application, given that injury is not explicitly defined, the HCLA should be interpreted broadly. And the injury should be accorded the definition of something to the effect of any wrong or damage done to another's person, rights, reputation, or property. And that is the definition of injury in many, many other contexts. For instance, USERA, professional malpractice, and given that the HCLA is broad and is supposed to encompass many theories of liability, it's the plaintiff's position that injury can encompass a violation or invasion of a legally protected interest, like a legally protected interest in privacy and a legally protected interest in dignity. The plaintiff briefed the Residents' Rights Act, which explicitly codifies those rights. The right to privacy, the right to dignity, the right to be free from abuse. So our legislative body has already told this court, hey, these rights are important and they're legally protected. And a violation of those rights ought to constitute an injury. Now, the appellee is going to probably come up here and tell you that this is not a cause of action. The Residents' Rights Act doesn't allow for a private cause of action, and that the plaintiff is trying to create a new cause of action out of whole cloth. That's not the case. The plaintiff is merely stating, hey, these rights are codified. They're important. They mean something. They have value. And the legislature has told us that because they've put that into policy explicitly.
Well, I think I'm sorry, go ahead.
In terms of the added claim in amending the complaint, stated in terms of invasion of privacy, and there are different species of privacy torts. Is this an intrusion upon seclusion claim? Is it a different type of privacy tort? What type of privacy tort are you asserting?
Judge Eastman, the privacy tort of intrusion upon seclusion. There was some citation to, I believe, a different kind of case. I believe it was called Lineberry. I believe Lineberry was the case. That was actually a publication of private facts case. And so the appellee has raised that, look, there wasn't enough public exposure here. The only people that saw the video was this inmate and the person supervising him, and then the director of nursing and anyone else that was necessary to view the video and identify the resident and the perpetrator.
Counsel, I have a fact question with regard to that. The briefing from opposing counsel says there's no recording here. My understanding, though, is that there was a review of this video by officials from the center, so they're not watching it live, clearly. So was there a recording that's been deleted? Is that what the facts would show? Was there, presumably something has to have been recorded for officials from the medical care facility to have seen it at the prison. Do we have any further understanding in terms of the facts of that viewing?
The facts, as I understand it, Your Honor, I am not sure if the video exists at all anymore. To my knowledge, it doesn't. It may have been viewed live and then reported. It may have been reviewed later and then reported and then disposed of. We've not deposed anyone at the prison or gotten any information from them yet. Only the parties in this case have been deposed this far. So I'm not sure, but the parties do agree that this occurred. There's no disagreement about what was depicted on the video. What was depicted on the video was a side profile view of Miss Jones nude. It depicted the two CNAs removing her brief. So that was all visible on the video. That's a very vulnerable state for someone to be in. The state of Tennessee came in and investigated and said, yeah, this was abuse. The facility failed to protect Ms. Jones from that abuse. They failed to properly report that abuse. In fact, the family wasn't told for a week that the abuse even occurred. And when they were told, it was implied to them that she was just filmed on camera. It was not disclosed to the family immediately that she was filmed in that state during a shower. So there's no dispute about what the video depicts, whether it exists or not. But we are still trying to get more information about what happened to the video and who disposed of it, if it was disposed of.
Well, it certainly appears to me to be an invasion of privacy, if not other things. But how do we determine damages? Where do we go with the concept of damages?
Yes, Your Honor. Economic damages, of course, include all the things that you can objectively verify, but we also have non-economic damages. And so the defendant, of course, cites to West versus Media General Convergence, which was a different kind of invasion of privacy. It was a false light claim. It was a speech-based claim, and there the heightened defamation standards applied, which meant that the plaintiff had to prove actual damages, but that's not the case here. So the plaintiff would submit to you that general or economic or non-economic damages are appropriate, and those are codified as including physical and emotional pain, suffering, inconvenience, physical impairment, disfigurement, mental anguish, et cetera, and, quote, all other non-pecuniary losses of any kind or nature, and that's codified at section 29-39-101. And the determination of such non-pecuniary losses, those involve a subjective element, right? They're hard to quantify. They're not easily quantified like economic damages like medical bills and things of that nature. The jury trial guarantee requires that subjective element be determined by a jury. And here, it was determined by the judge. The judge said there aren't any damages. These violations do not have any value. The plaintiff respectfully disagrees. Damages that are not easily quantified are left to the sound discretion of the jury all the time. And that's, you can see that this court issued that opinion in Smart versus NHC. And so it was not the trial court's province to determine the value of those violations. The defendant will also tell you that nominal damages are never appropriate, but again, because we're traveling under the HCLA, which is broad, nominal damages should be appropriate as well to rectify, to vindicate those rights that were violated. And Your Honor, it simply cannot be the case that the defendant admits that Ms. Jones suffered abuse in its facility, and yet also that absolutely no compensable legal wrong occurred. As a matter of public policy, the defendant's position does nothing to deter poor care delivered with utter disregard for a vulnerable individual's dignity or privacy. And I'll yield my time.
All right, thank you, Ms. Martin. We'll hear from you again on rebuttal. We'll now hear from the appellee.
I got too many things.
Good morning.
Good morning. May it please the court. I'm Alan Bean. I represent Life Care Centers of America and Life Care Center of Tullahoma. Judge Clement, I want to start with the question that you asked opposing counsel, which is there a remedy when a nursing home resident may not be aware of an action like this occurring? My answer to that, Your Honor, would be under the current state of Tennessee law, the answer is there is no civil action that would provide a remedy in terms of money damages for this action. There are other remedies available, however, and in fact, they were employed in this case. The state of Tennessee investigated. The state of Tennessee made a finding of abuse. The state of Tennessee required the facility that I represent to submit a proposed plan of action. The 3 employees that were involved were absolutely terminated in quick fashion. So there are other remedies available, but I would submit to this court that in the setting of a civil case for money damages, where there's no proof of an injury or, and I think this is related, I will admit, it's hard for me to conceptually split the two, but when you have an injury or a loss without any accompanying damages that have been proven, I would submit to you there is no civil action in Tennessee that would provide a remedy under those facts.
Counsel, isn't the intrusion upon privacy itself the damages here? I'm looking at section 652H of the Restatement Second of Torts, and under damages, it provides one who has established a cause of action for invasion of his privacy is entitled to recover damages for the harm to his interest in privacy resulting from the invasion. And then the comment specifically lists, in terms of intrusion upon seclusion, thus one who suffers an intrusion upon his solitude or seclusion may recover damages for the deprivation of his seclusion, and treats that as separate from recovering damages for emotional or personal humiliation. So isn't the intrusion upon privacy itself the damage, the harm with regard to the action here?
I would submit that there still has to be proof of what the deprivation upon the seclusion actually caused. This is such a unique set of circumstances where there's no proof whatsoever that there was any reaction, any effect of this occurring. And you almost have to just assume, as you did, that well, let me say it this way. If we're automatically to assume that there is going to be some element of damages associated with an invasion of privacy for intrusion upon seclusion, I don't know why they would have made that damages part a separate element. It seems like it would be an almost, as soon as you prove that there has in fact been an intrusion, you don't have to prove damages. The fact that that is an additional element that you just read, to me, suggests that there has to be some proof, and it may not be limited just to emotional distress.
Counselor, under your understanding, let me think of a little different scenario here. Let's say we have a hotel. There's a bad acting manager at a hotel who puts in hidden cameras in a bathroom in the hotel. Are you saying that if the person is not aware that they were recorded, that there's no harm that has occurred under Tennessee tort law?
I would submit to you that in that setting, if there was proof that someone else viewed the video and that they in some way, I don't know, gained something from the video, publicized it, then you could potentially have a cause of action. But under your hypothetical, if it's recorded and that's the end of it,
Are managers watching the video and there's no harm that's happened to that person?
Without something else, I don't believe so under Tennessee law, and certainly not under the facts of this case. I mean, let me also mention this. Under that situation under your hypothetical, does the person in the hotel room become aware at some point that the manager watched the video?
Well, Counsel, in your briefing, you suggest there has to be severe emotional distress. You sort of draw the comparison with an NIED claim. And let's say the person's just mad, and they're not going to see a psychotherapist. They're just really upset about it. They find out that, hey, I was recorded in a shower naked by this bad acting hotel manager. And under your theory here, I don't think they've had any harm, if we accept your theory.
No, I disagree with that.
Okay, how do you distinguish that?
Here's the distinguishing factor. You just said that there would be an invasion of privacy with intrusion upon seclusion and a person who is upset about the fact that they were videoed. That's what we don't have here. We don't have any proof that Ms. Jones was ever aware or upset that this happened.
Well,
now,
you have the good fortune from your point of view to have a disabled plaintiff, and should that piece of good luck on your part make all the difference?
It certainly doesn't in the context of an investigation by the Department of Health, the Board of Nursing, or
That's not what we're talking about.
But in a civil action, Your Honor, I do not believe that Tennessee law provides for a civil action, even under that setting. As much as that may upset us, I do not believe that Tennessee law would provide for that unless there is proof of awareness. Then we might have an invasion of privacy claim, or a negligent infliction of emotional distress claim if there's expert proof of a serious or severe injury. We don't have either.
Is there no analogy to other tort cases where one takes the plaintiff as one finds them, and doing something to the thin-skulled plaintiff who is unusually vulnerable doesn't let you off any just because they're unusually vulnerable? And these are the most vulnerable people.
I don't argue with you about that, Judge, but I will tell you in answering your question, I'm not aware of a single case in Tennessee where without a physical component to an injury and without any proof that someone's aware of what's happened, or certainly that there's any manifestations, physical or emotional, of that there would be a valid cause of action under Tennessee law for it. And that's just the way that I read Camper versus Minor. That's the way that I read the Abeta case and the Hatfield case, both of which included, and those were both loss of privacy, loss of dignity claims, both of which included physical injuries. That's the difference. When you are asserting, as the plaintiff is here, a purely emotional category of injuries. And I think, frankly, whether we call it an emotional injury, a loss of privacy, a loss of dignity, it's really semantics. I mean, without a physical component, we're talking about an emotional
The restatement
injury.
draws a distinction between those two expressly in the comments. I mean, Part A is telling us that it's recovering damages for deprivation upon seclusion, whereas B, plaintiff may also recover damages for emotional distress or personal humiliation. So if we're going to adopt the approach you're suggesting, I think it puts us in contravention, or at least it looks like it puts to me, in contravention of 652H. So, and the restatement comments are distinguishing between emotional injuries and intrusion upon privacy injuries.
I would respectfully submit that the hypothetical you gave me tells us the answer, which is there has to be at least some awareness that it's happened. There is not a single case in Tennessee, at least that I've been able to locate, on any type of invasion of privacy claim where there is an absence of actual knowledge that something happened. The cases we've cited, including the publication cases, at least include the fact that someone is aware that this happened. And that is the fact that's missing when we address the invasion of privacy issue, which is, of course, was denied because of a futility. So that's an abuse of discretion standard. But
returning to Judge Bennett's question, doesn't that raise serious public policy concerns about exploitation of the most vulnerable members of our society, whether you're talking about the elderly or candidly children? And in terms of, you can have children that are too young to appreciate what's occurring in terms of recording, that under the argument that you're advancing here, there's really no tort law protection against the injuries that the intrusion upon seclusion that is suffered by those individuals.
what I would say is there is no tort protection in terms of a civil action under these facts for that cause of action. I would again say that in addition to the actions by the state of Tennessee and the Board of Nursing and the Department of Health, you also, we get into exploitation of children and we truly get into exploitation of someone, that's a criminal action. There's your deterrent. There's your public policy. So, I mean, let's frame it.
We're not talking about criminal actions. This is a different animal. Let's don't get into that stuff.
Well,
what if this had been a child? Okay, accident, wasn't intentional. Not a crime. Just it's a child, and it happened. Now, wouldn't we let the child's parents or guardians or whoever file a lawsuit?
You might let them file a lawsuit, and if they asserted a claim upon them for themselves individually, which is not the case here. In other words, not only a claim on behalf of the child who's not aware, but an individual claim the parents are bringing because they've been distressed by knowing this, that might qualify for an NIED claim if you can establish the elements.
But nothing for the child.
Nothing for the child if the child's not aware. Now, again, when you say nothing, I'm just talking about from a civil standpoint.
That's what we're talking about.
Your Honor, under current Tennessee law, I'm afraid the answer is yes. Again, going back to this issue of injury and damages, I would submit to Your Honors that summary judgment was appropriate because there's no proof in the record of the essential element of an injury. We've heard from counsel today, and in fact it's been conceded multiple times, that every one of the claims that plaintiff might bring here falls under and is subject to the Health Care Liability Act. The Health Care Liability Act requires expressly proof of an injury. That's the word that the legislature chose to use, an injury. We also know it's conceded that Ms. Jones didn't know this event had happened, and also that plaintiff has conceded that Ms. Jones is not claiming any physical, mental, or emotional injuries. I find that concession telling. Again, I think we're really getting into a little game of semantics here, but I don't understand how you can assert that someone hasn't suffered a physical, mental, or emotional injury. And again, I'm talking about, for this moment, the Health Care Liability Act claims. I don't understand how you could ever concede that you haven't suffered a physical, mental, or emotional injury. and yet expect to survive summary judgment, particularly when there's no proof of damages. You can claim a loss or an injury, but what is an injury or a loss if there's not any damages? I would submit to you
Counselor,
that
aren't privacy harms? I know, aren't those damages?
I would submit that they're a little different, that you can have an invasion of privacy, and someone can say, you've invaded my privacy, but that person would still have to prove some damages, and we don't have any proof of damages in this record. I will respectfully disagree with my adversary that it's basic black letter Tennessee law that nominal damages are simply not appropriate in a negligence action. We've quoted the cases, cited the cases that provide for that. So I would submit to you that, and I'll also add this because there was a reference earlier to maybe taking additional discovery. Your Honor asked about, has anybody else viewed the video? Was it recorded? I'll agree with opposing counsel that the proof in the record is the video may have been recorded, but it is no longer available. Certainly there's no evidence that it is available. But I do want to emphasize that in response to the motion for summary judgment, there was not an affidavit or a request under Rule 5607 to conduct additional discovery to be able to respond to the motion for summary judgment. Additionally, at the hearing on the motion for summary judgment, Judge Lockhart asked Ms. Martin, do you need to take any additional discovery? She said she did, but it's limited to expert discovery, to deposing the expert that we disclosed. So to the extent that there's any suggestion or any concern about being denied the opportunity to further explore the extent of the publication, if we want to call it that, or the recording, I would submit to you that that has been waived. Additionally, Your Honor, going back to the NIED claim, which I respectfully submit that is the gravamen of this claim. Negligent infliction of emotional distress in the setting of a Healthcare Liability Act case, because this was involved in the provision of healthcare. That type of claim, according to the Tennessee Supreme Court since 1996, requires expert proof of a serious or severe emotional distress. There is no such expert proof in the record before you today. Dr. Klein, who was included in the plaintiff's response to the motion for summary judgment, provided an affidavit which said there's been a loss of privacy or dignity. There is not any proof before you that that was a serious or severe emotional injury or emotional distress. That is dispositive on the NIED claim, I will submit to Your Honor. Additionally, in deposing Ms. Sons, who's Ms. Jones' daughter, she conceded on the record that there's no proof whatsoever of any physical or emotional manifestations of this injury, if we want to call it that. And that's all cited in our brief. Damages, Your Honor, are an indispensable element of a tort claim. There's no proof of damages here. There's no economic damages. There are no special damages. No proof of pain and suffering. No proof of physical injury or loss. No proof of any mental anguish or emotional distress. So I would respectfully request that this court affirm the ruling of the trial court. Again, from a public policy standpoint, that is a valid concern. But I would submit to you that under Tennessee law, and in the specific setting of a civil action for monetary damages like this one, there is no remedy for the plaintiff. There is no remedy because there is no injury or proof of an injury. There is no proof of damages under Tennessee law. And to hold otherwise would essentially, despite what counsel said earlier, create a new cause of action where you can assert a loss of dignity or privacy without proving injury or damages. Thank you, Your Honor.
All right, thank you, Mr. Bean. And Ms. Martin?
Thank you, Your Honors. I do want to correct one thing as an initial matter, and that is the plaintiff has never even whispered anything about a negligent infliction of emotional distress claim. There are no facts pleaded that add up to an NIED claim. The plaintiff has not asked to amend her complaint to assert an NIED claim. So there's no need to be talking about an NIED claim. So I understand the defendant's position that NIED claims require require proof of severe emotional damages, but that's just not the case that we have here. And I think Judges Bennett and Usman have hit the nail on the head, and that is whatever this court decides today will mean something for future cases. And my question is this, it's where does that end? What about children who don't understand what's happened to them or know what's happened to them? What about cases where, what if this had been a worse case? What if this perpetrator had fondled Miss Jones and she had no idea what happened? There are cases where people in comas have been molested. These are all very obvious cases where abuse has occurred. And if we go all the way back to Marbury versus Madison, that violation has to have a remedy. And a jury can decide what that remedy is. That is precisely what non-economic damages or general damages are for. They're to vindicate a right that has occurred, that is difficult to quantify, and that is precisely what happened here. And Your Honors, if the bench doesn't have any more questions, I'll simply just ask that you reverse the lower court's decision.
All right, thank you, Ms. Martin, and
Thank you.
nice to see you again. And Mr. Bean, very nice to see you again. It's been a very long time. All right. Thank you both. This is an important case, and we will give it our due consideration and take it under advisement. Call the next case, please.
Linda Mears versus Nashville Center for Rehabilitation and Healing, LLC.